I began to be involved in cases like the McMartin preschool case in 1985. So that case had started already before I had any familiarity with this issue. But in 1985, I first got a call from a defense attorney about certain role that psychiatry was playing in a case that he had where he was defending a man who was accused of molesting his son. It was a divorce, parents were no longer together, and he was accused of having molested his son. And he told me, well, Dr. Coleman, I know your work because I've opposed you several times when you were testifying for the prosecution about a mental defense, because indeed I had started doing that kind of work in 1975. Prosecutors were calling me to explain the lack of scientific methodology behind psychiatric testimony in the insanity defense, another mental defense called the diminished capacity defense. So this defense attorney in 1985 knew me not only from maybe he had heard of me, but he'd opposed me by cross-examining me in the court. But nonetheless, he apparently had a high enough opinion of my work that he now was asking if I could help him in his kind of case. Because he said, I know what you think of these psychiatric examinations. Well, in my case, there's a doctor who's got this thing he calls the accommodation syndrome, and they're claiming that that syndrome is helpful in showing that your guy did this molestation. And I said to him, well, I've never heard of that syndrome. I've never heard of that doctor, but I know psychiatry, and I can tell you there's no syndrome that exists that could possibly help in whether or not somebody's committed a crime. I don't care whether it's bank robbery, murder, or child molestation. There's no syndrome that is supposed to be either in the child or in the perpetrator that exists that would help you say you committed this crime. So yeah, I'll take a look at your case. Send me everything you got. So he did, and that's how I got involved in this issue. I began to do that because it was an issue that was exploding across the country, and when I saw in that very first case how atrocious it was, I began to ask about what's going on. Are there people responding to this? Are there lawyers and accused? And quickly, very quickly, began to go to meetings and be asked to present, because there was virtually nobody in the mental health profession who would speak up about it. Okay, with that background, that's why I was called by one of the defense attorneys in the McMartin case in 1985. There were 7 people accused of molesting hundreds of children over a span of 10 years. So it was supposed to have gone back to the 70s with about 400 children allegedly molested at the McMartin preschool. And I was contacted by the defense attorney for one of the 7. And these were teachers at the school, the founder of the school, and the founder's daughter, and the founder's granddaughter. So in their late 20s, maybe 50, and in her 70s, 3 women, and then bunch of teachers. So I learned the case by watching about 60 hours of videotaped interviews of the children who were possible witnesses, ranging from 4 years old to early teenage years, because they were allegedly victims when they were 3 or 4, but now could theoretically talk about things that happened. I learned about the case by reading reams and reams of testimony from the preliminary, from interviews with various people, police work, the transcripts of the tapes. I learned about the medical examinations, which were claiming to find medical abnormalities in the anal and genital region of dozens of children by qualified pediatricians. And when I studied the case, I saw a complete sham. I saw massive evidence, not of anybody ever molesting a single child, but massive evidence of collusion and irresponsibility between the police investigators, the district attorney's office, the medical examiners, everybody, and the media, which the Los Angeles Times was reporting this as the most egregious form of unbelievable abuse that could be imagined, and it's just a matter of how many decades should they serve. And there was absolutely nothing to it except this kind of irresponsibility. And ultimately, what happened is it went to trial. I testified in a civil phase of the trial because when a new district attorney came in, Ira Reiner came in to replace Philibosian. Philibosian and his office had never looked at 1 minute of one interview that was videotaped. Never looked at it, but nonetheless had indicted 7 people and were about to take him to trial. When the new district attorney came in, they decided to look at the tapes, and they immediately said, there is no evidence except mere suspicion, and dropped the charges. But they didn't drop the charges against 2 people. Anybody who knew the case, as I now did, would know the evidence was the same against everybody. There was no evidence. So they should have been dropped against all 7. I'm sure for political reasons they couldn't do that. So they prosecuted Peggy Bucky and Ray Bucky. That's the daughter of the founder and the grandson, one of the grandchildren of the founder. I should tell you that the way the case started is very important. It was a 2.5-year-old boy who was noticed by his mother to be scratching his anus at night and crying and very fussy at night. He was taken to a hospital. They found some evidence of scratching, superficial abrasions, nothing else. They did not do a simple home or a simple maneuver that any nurse could do. They did not take a piece of Scotch tape and put it on his anus and then pull the Scotch tape off and look under a microscope. A procedure which causes no pain, is not invasive, you're not going into the anal canal, and under the microscope you can see what was almost certainly the cause: pinworms. Very common in children. The symptoms are nothing during the day usually, scratching and discomfort at night. Exactly what this boy had, because the female worms, somehow, I never figured out how, they know it's nighttime. They come out and they lay the eggs in the skin around the anus, and that itches the child. They never did that. Instead, because the mother thought, I think somebody's been sodomizing my child, and the only place he goes is to the McMartin preschool. Because of that, the doctors who initially examined the child and didn't do the Scotch tape got scared. That's my surmisal anyway, but I know what they did. They sent the child to the UCLA Medical Center, where they had a newly composed sexual abuse team. And they said, suspicious of sexual abuse. And then the case took off. Then the police investigated. They wrote a letter to the community saying, we've talked to the children, but none of them have told us of any abuse. We think they're afraid. So talk to your children and ask them if anybody's been touching their anuses or their penises or their vaginas. And of course, once that was done, children begin to say some things that the parents claimed they were saying. But the police never got a single child who ever repeated it to them. And as a result, a district attorney named Jean Matasinka, a woman, J-E-A-N, Jean Matasinka, who was one of a beginning cadre of professionals, mental health professionals, lawyers, social workers. who were inventing a new form of investigating child sexual abuse. She said, I know the person who knows how to interview children and help them say what happened to them. So they were sent to the Children's Institute International, headed up, as far as the interviewing it goes anyway, by Key McFarland, a social worker whose only license in California was welding. And she became the lead interviewer and taught those children to say the things that the smart children would know to say, that they had been abused by every imaginable thing, that they had been taken on airplanes, that they had dug up horses and did unimaginable and physically impossible things. And they were the witnesses in the trial, which resulted in no convictions. Ultimately, out of hundreds of charges, they had three trials, two trials. Each one, a vast majority, were not guilty, but some hung jury, they call it, where it's not unanimous. Ultimately, the prosecution finally gave up with not a single conviction. But Ray Buckey, to this day, still suffers from the fact that if you look him up on the computer and you're an employer, you can find that they never dropped the charges. They're unresolved because it was a hung jury on some counts. So his life has been influenced forever. So that's the McMartin case, and that's the role that psychiatry and medicine, or at least certain people in those professions, played in that case. And I'm proud to say that Peggy Ann Buckey, who was one of the 7 people who the charges were dropped against, I testified on her behalf in her administrative law case to get her job back and her back pay. She got her job back, she got her back pay. So far, she has many things to do in her life. But let me just add one other thing. If my grandchildren ever needed 24-hour care, and her parents, my son and his wife, had to go off for vacation, and I wasn't available, my wife wasn't available, I could think of nobody better than Peggy Ann Buckey, this alleged child molester. And that's the McMartin case.